Welcome to the 7th video on the weekly legal update series. In this video, we will be discussing important legal events from 14th December to 19th December 2020. In first important news, the Supreme Court has issued a notice in the matter relating to sacramental confessions. Supreme Court has issued a notice on a petition challenging the practice of mandatory sacramental confessions in the Malankara Orthodox Syrian Church. The primary question in this petition is that whether mandatory requirement of confessions can be imposed on a believer according to section 7 and 8 of the 1934 Constitution of the Kerala Malankara Church, and whether these would be protected under Article 21 and 25 of the Constitution as an essential aspect. In second important news, the Supreme Court has observed that filing of the closure report cannot be done solely because the informant did not supply sufficient materials to investigate. In the case of Amarnath Chaubey versus Union of India, a 3-judge bench has observed that a closure report cannot be filed merely on the ground that the informant has not supplied adequate materials to investigate. The court has noted that it is the statutory as well as the constitutional duty of police to investigate a cognizable offence. Additionally, Article 14 and 21 of the Constitution also mandate a right of fair investigation. Therefore, a closure report cannot be filed solely on the ground that the informant has not supplied them with adequate materials. In third important news, in a landmark decision, the Supreme Court has noted that landlord-tenant disputes under the Transfer of Property Act are arbitrable except when they are covered by the rent control laws. The Supreme Court has noted that landlord-tenant disputes will be arbitrable except when they are covered by a specific forum which is created by the rent control laws. It further notes that Transfer of Property Act neither forbids nor forecloses arbitration. The Supreme Court in this case has also overruled its earlier decision in 2017 in the case of Himangni Enterprises versus Kamaljeet Singh Ahluwalia. The court has further noted that, however, when such disputes are covered by any rent control legislation, then they would not be arbitrable, for the presence of a specific court or a forum has already been granted exclusive jurisdiction. In fourth important news, the Supreme Court has said that summary eviction procedure cannot be invoked to defeat the right of residence of a woman in a shared household. In the case of S. Vanitha versus Deputy Commissioner Bengaluru Urban District, a 3-judge bench has noted that under the Maintenance and Welfare of Parents and Senior Citizens Act, this act does not have an overriding effect over the rights of residence of a woman in a shared household which she gets under the Protection of Women from Domestic Violence Act. The court has noted that when there are two special legislations containing non-obstante clauses, then both the legislations have to be harmoniously construed, and the provisions of Maintenance and Welfare of Parents and Senior Citizens Act cannot override the remedies which are provided to a woman under the Protection of Women from Domestic Violence Act. In fifth important news, the Supreme Court has said that disputes which are adjudicated by DRTs are not arbitrable. In the case of Vidya Rolia versus Durga Trading Corporation, the court has noted that disputes which are to be adjudicated by the Debt Recovery Tribunal are not arbitrable. The court in this case has also overruled a Delhi High Court judgment in the case of HDFC Bank Limited versus Satpal Singh Bakshi. In sixth important news, the Supreme Court in a suo motu petition has acknowledged that affordable treatment is a part of fundamental right of health. In a suo motu writ petition, Justices Bhushan, Reddy and Shah has acknowledged that fundamental right to health includes affordable treatment. It has also suggested that capping of the fees of private hospitals can also be provided for to make sure that the fundamental right to health is also inclusive of the affordable treatment. In seventh important news, the Supreme Court has noted that prior to conviction on same day, vote cast by lawmaker is not invalid. In the case of Pradeep Kumar Sonthalia versus Dheeraj Prasad Sahu, the contention was that the applicant casted a vote in the morning and then he was later convicted for a criminal offense at the afternoon 2:30 p.m. Then the question was that the vote that has been casted by him earlier in the morning before the conviction was announced, whether that would be valid or not. So the court has noted that a vote cast by a lawmaker prior to his conviction on the same day in a criminal case cannot be termed as invalid. The court has noted that in as much as a conviction for an offense is under a penal law, it cannot be deemed to have effect from a point of time anterior to the conviction itself. So this brings us to the end of our video. Do like, share and subscribe for more customized updates.